Bin, B-I-N?
BIN, my lord.
Yes.
Appearing for the first garnishee applicant.
Okay, so I'm going to proceed to deliver my ruling, and I'll be reading directly from my system.
As the court pleases.
As court pleases.
So here's the ruling of the court.
As court
The
pleases.
Central Bank of Nigeria, CBN, was a garnishee in suit number NICN ABJ 310M 2021, where this court made a garnishee order absolute on 15th May 2024, directing the garnishee to pay the sum of 44,265,163 naira 64 kobo from the monies in its custody due and standing to the credit of the judgment debtors into this court in satisfaction of the judgment debt arising from the judgment delivered on 14 February 2013 in suit number NICN ABJ 219-2012. The garnishee was also directed to pay the sum within 30 days from the date the order absolute was made. The court made the order absolute after dismissing the garnishee's motion for stay of the garnishee proceedings pending appeal and the judgment debtor's motion for stay of execution of the order NICI made on 17 December 2021. On 17 May 2024, the garnishee filed another motion seeking the following prayers. 1. An order staying the execution and or enforcement of the judgment of the National Industrial Court Abuja Division, Quorum Justice O.Y. Anuwe, delivered on 15 May 2024 in suit number NICN ABJ 310M 2021 between Engineer Kalu Judge Egbeke versus Federal Polytechnic Ida and Central Bank of Nigeria and 3 others pending the hearing and determination of the appeal filed by the applicant at the Court of Appeal. 2. An order of injunction restraining the judgment creditor either by himself, servants, agents, privies, other persons acting through him or at his behest from taking any steps in executing or enforcing the judgment of this honorable court delivered on 15th May 2024 in suit number NICN ABJ 310M 2021 by any means whatsoever pending the hearing and determination of the appeal filed by the applicants to the Court of Appeal. And 3, for such order or orders the court may deem fit to make in the circumstance of this case. The motion was supported with an affidavit and a written address. The garnishee applicant filed 3 further affidavits in support of the motion on 22nd May 2024, 23rd July 2024, and 11th November 2025. Exhibited to the affidavits are copies of the application for leave to appeal together with the proposed notice of appeal. The ruling of this court delivered on 15th May 2024 in suit NICN ABJ 310M 2021 and the application to the registrar of this court for compilation and transmission of record of appeal. See Exhibits GE1, GE2, and FB1. In opposing the motion, the judgment creditor filed a counter affidavit and written address on 11th October 2024, but didn't file on 11th November 2025. I have carefully examined the averments contained in the affidavits in support of the motion and the counter affidavit of the judgment creditor respondent. I have also considered the submissions in the written addresses of the parties. In the affidavit in support of the motion, it was averred that after this court dismissed the garnishee applicant's motion for stay of proceedings pending appeal on 15th May 2024, the garnishee applicant filed an application to the Court of Appeal for leave to appeal against the ruling and also applied for the compilation of the record of appeal for transmission to the Court of Appeal. The Court of Appeal is yet to give a date to the parties for the hearing of the application for leave to appeal. From all that was stated in the affidavits of the garnishee applicant, the reason for asking this court to stay execution of the garnishee order absolute is that it has a pending motion before the Court of Appeal for leave to appeal against the decision. The said motion filed in the Court of Appeal is Exhibit GE1. The Ganishi applicant confirmed that the motion has not been heard by the Court of Appeal. By the rules of this court, the court does not grant applications of this nature when it is apparent that leave to appeal has not been obtained from the Court of Appeal or when appeal has not been entered in the Court of Appeal. See Order 64, Rule 13.2 of the NICN Rules 2017. Under this rule, the conditions under which this court grants application for stay of execution pending appeal is when it is shown that the appeal has been entered in the Court of Appeal and that there is a valid appeal before the Court of Appeal. Also, where the appeal is one which requires leave to appeal, the applicant must show that leave has been obtained. Rule 13.3 of Order 64 directs the court to consider whether to grant or refuse the application for stay of execution only when the requirements in Rule 13.2 have been complied with. From the averments in the affidavits of the Ganishi applicant, it is clear that the requirements of Order 64, Rule 13.2 of the rules of this court have not been complied with. Consequently, this court cannot grant the prayer sought by the Ganishi applicant. Learned counsel for the Ganishi applicant has urged me to allow the Ganishi applicant continue to keep the attached sum in his custody pending appeal and recommended the decisions of the Supreme Court in CBN versus J.I. Nwayahu and Sons, judgment delivered 18/11/2002 unreported, and CBN versus Seidu H. Ahmed, 2001. To guide me in that respect, I have read these authorities. I have previously directed the Ganishi applicant in the ruling of 15th May 2024 to pay the attached sum into this court. That order is still subsisting, and it is not the one subject of the pronouncements of the Supreme Court in the cases cited by the learned counsel for the Ganishi applicant. I will maintain my earlier order. Thus, to preserve the money pending when the proposed appeal of the Ganishi applicant will be determined by the Court of Appeal, the money shall be kept in the account of this court through the Chief Registrar of the court. Accordingly, the application of the Ganishi applicant is refused. The Ganishi applicant is ordered to pay the attached sum to this court for safekeeping, pending when the proposed appeal will be determined by the Court of Appeal. No order as to cost, ruling is entered accordingly.
As the court
As court
pleases.
pleases.
We are most obliged, sir.
As God
Thank you.
pleases.
Thank you so much, sir.
Thank you. So, you get your ruling later today, probably before noon. As soon as I'm done sitting, it will be sent across so that I can get it signed.
Thank you so
All
much.
right?
Thank
Yeah.
you, sir.
Thank you.
Yes.
Thank you, my
So-
Lord.
Thank you very much. And do have a
Thank you.
very, very fulfilling 2026.
Thank you so much, sir. We also wish you a remarkable year, sir.
Thank you.
Thank you.
Yeah.
Yeah.
Mohammed, you want to call the second case?
Yes, Lord. Case number NSN/ABJ/MN/55/2024 between Bashir Awal Bobi and Niger State Judicial Service Commission. Lord, parties absent.
Appearances, please.
Honorable Court,
Yes.
Sambo is my name.
Yes.
M. Sambo.
Yes.
Appearance is for the plaintiff.
With all respect to my lord,
Yes.
Abubakar Suleiman, Chief State Counsel for the defendants.
Okay. So again, I'm going to proceed to deliver the decision of the court, and it will be read directly from my system. This suit is an application for judicial review filed by the applicant pursuant to the provisions of Order 48 Rules 1, 3, 1, 2, 4, and 10 of the 2017 rules of this court. The reliefs sought by the applicant in the originating motion are as follows. I have set out the relief sought. There are 12 reliefs, and I have read them out in the body of the judgment. I would not bother reading them. They're already embodied therein. I have also made a summary of the case of the claimant. That is the applicant. Case of the applicant, and also the defense of the respondents. The respondents' defense to this application. I have also summarized it in this judgment. The applicants also filed a further affidavit and reply, which I have again summarized. I will now proceed straight to the decision of the court.
As court pleases.
As court pleases.
The applicant is a public servant in the service of the first respondent. He was the presiding judge of the Upper Sharia Court, Rijal, Niger State, until 13 September 2024, when he received 2 letters from the first respondent notifying him of his removal as a judge and demotion by 2 ranks. The events resulting to the communication of these punishments to the applicant are that on 26 February 2024, the first respondent received a petition against the applicant. The petition, which is dated 26 February 2024, is Exhibit BOBI 3, BOBI 3. Upon receipt of the petition, the first respondent forwarded same to the applicant through a letter dated 27th February. Hmm. 27th February 2024 for his response to the obligations therein, and the applicant submitted his response to the first respondent on 29th February 2024. I'm sorry, I am just trying to get the most comfortable position. See Exhibit C of the respondent's counter affidavit. On 6 March 2024, the Chief Judge of Niger State, who is the chairman of the first respondent, constituted a committee to investigate the allegations made against the applicant in the petition. The appointment of members and the secretary of the committee was communicated to them via the letters dated 6 March 2024. See the applicant's Exhibit BOBI 4 and the respondent's Exhibit A. On 11th March 2024, the first respondent received a letter from J.S. Ricoto Esquire, who wrote the petition, giving notice of withdrawal of the petition. The letter is Exhibit BOBI 5. By a letter dated 13th March 2024, Exhibit BOBI 10, the first respondent informed J.S. Ricoto Esquire that an investigation committee had already been constituted and that the petition can only be withdrawn by an affidavit refuting the allegations. J.S. Ricoto Esquire was accordingly withdrawn by an affidavit refuting the allegations. J.S. Ricoto Esquire was accordingly invited to the committee to prove the allegations. The committee commenced its proceedings on the petition on 14th March 2024, and upon concluding investigation, submitted its report to the first respondent on 27th May 2024. The report of the committee the report of the committee that the first respondent issued and served the applicant the notifications of removal as a judge and demotion by 2 ranks via the exhibit Bobby for the Bobbies 7 and 8. By this application for judicial review of the disciplinary proceedings, the applicant is seeking an order of certiorari, quashing the entire proceedings and findings of the investigation committee of the first respondent and the decision of the first respondent contained in exhibits Bobby 7 and 8. Having examined the facts of the application and the submissions of the counsel for the parties in their respective written addresses, the issue I will determine in this application is whether the applicant has made out a case for the grant of an order of certiorari. Judicial review of certiorari is one of the prerogative orders of court, and its function primarily is to ensure that inferior courts, tribunals, administrative bodies, or anybody entrusted with the performance of judicial or quasi-judicial functions keep within the limits of the jurisdiction conferred upon them by the statute which created them. Whenever anybody or persons having legal authority to determine questions affecting the rights of persons and having the duty to act judicially or in accordance with a laid-down procedure acted in excess of their legal authority, certiorari will lie to quash the offending acts or decision of such body or persons. In other words, an order of certiorari will lie to remove into the High Court for the purpose of being quashed any decision or proceedings of an inferior court, tribunal, administrative body, or authority where the decision or proceeding is unreasonable, or there was lack of or excess of jurisdiction, or there is non-observance of the rules of natural justice, or there is error on the face of the record of such inferior court, tribunal, administrative body, or authority. See EPO versus Calabar Local Government 1993, Osun State Water Corporation 2002, Anuwe versus GM Osun State Water Corporation 2002, University of Uyo versus SL 2006. Order 48, Rule 1 of the rules of this court permits a person who desires that a decision or proceedings of an arbitral tribunal or of any commission or board or any other institution vested with power to deal with any matter arising from a subject matter within the jurisdiction of the court be reviewed, to commence the review process by an originating process. The first respondent in this application is a statutory body established in Section 197C of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The first respondent is the employer of staff of the Judicial Service of Niger State and also has the power to discipline the staff of the Judicial Service of Niger State. The first respondent is the authority who set up the committee that tried the applicant on the petition written against the applicant. It was also the first respondent that punished the applicant by removal as a judge and demotion by 2 weeks. In view of the provisions of the Constitution, the first respondent is empowered to act in quasi-judicial capacity in the discipline of staff of the first respondent. The proceedings and decisions of the first respondent in any disciplinary action against the staff of the first respondent are therefore subject to judicial review by this court and liable to be quashed where found to have been done in breach of laid-down procedure, or where the procedure taken to reach such decision was done in breach of the staff's right to fair hearing, or where the decision is found to be unreasonable. The applicant gave several reasons in this application for seeking the order of certiorari. To determine the issue for determination in this ruling, I will consider each of the complaints of the applicant to see whether the circumstances of this case will justify the grant of an order of certiorari. One of the complaints of the applicant is that the petitioners were not identified in the petition in contravention of Regulation 54(2) of the Niger State Judicial Service Commission Regulations 2018. And as such, the petition is incompetent and ought not to have been considered by the first respondent. In response, it was deposed in the counter affidavit of the respondents that the petitioner was Barrister J.S. Rikoto, who testified for himself as PW1 before the committee. Before I examine the petition to see whether it identified the petitioner or not, it is necessary to first examine the provision of Regulation 54(2) of the Niger State Judicial Service Commission Regulation 2018. Section Regulation 54(1) and 2 of the said regulation provide as follows. 1. A person may complain to the Commission about any misconduct or matter that concerns or may concern the ability or behavior of a judicial staff. 2. A complaint shall be in writing and shall identify the complainant and the judicial staff, service staff concerned. These provisions of Regulation 54(1) and 2 permit any person to forward a complaint to the first respondent against any judicial staff. In such a complaint, which must be in writing, the complainant must be identified. The purpose of the requirement for identity of the complainant is for the first respondent to know who is complaining against the judicial staff. The petition written against the applicant and received by the first respondent is Exhibit Bobby 3, and it reads as follows. Petition against the presiding judge, Upper Sharia Court, Rijau. Sorry, I'm using the opportunity to make necessary corrections. A petition against the presiding judge, Upper Sharia Court, Rijau, B.A. Bobby, for gross misconduct and corrupt practices. In Re Ibrahim Abubakar and 3 others versus Tanko Abubakar and 2 others. And Auta Magaji Bello versus Zagi Timbi and 6 others. Now, the body of the petition reads as follows. We are solicitors in the above cited cases, and we have the instructions of all our clients to petition the presiding judge, Upper Sharia Court, Rijau, before the Honorable Chief Judge and the Niger State Judicial Service Commission for proper investigation, accountability, and possible redress. Sir, our petition in the above cases is predicated on gross misconduct, corruption, and abuse of office meted on our clients by the judge without due regard to the rule of law. Sir, we note with sadness the following allegations. 1. The first case cited above is predicated on the sharing of estate of one late Alhaji Abubakar Rijau, who died about 44 years ago, instituted by one Atahiru Abubakar since 2018, now still pending before the Upper Sharia Court Rijau, without any progress made in the suit. The case was started by Honorable Alhaji Abdullahi Ahmad, who was later transferred after the case had reached distribution stage. The plaintiffs in the matter abandoned the case since then until sometime in 2023, when they approached the judge on the matter, who advised them to file a fresh case, and they filed suit number NUSC RJCV F1070-2023. That when the matter came up before the judge, we drew his attention to the fact that there's a pending case to the same effect, but he neglected the case and ordered our clients, who had been in possession of their farms for over 50 years, to stop work on the farm until it is distributed. Our clients informed him that their farms are not part of the estate of the late late Abubakar, arrested 8 of them, detained them, and collected the sum of 113,000 naira for bail. After he intimidated our clients, he colluded with the plaintiffs and sold one of the lands for 3 million naira, and the money was shared between him and the plaintiff without the knowledge and notice of the remaining heirs, even though at the time he sold the land, our client had already informed him that it was his personal land and not family. He sold the land to our client's tenants, who had been paying rent to our client for the past 18 years. He informed the tenants that he has confiscated the land and it is now the property of the court. That we confronted him and he denied selling the land, but we later discovered he sold the land and had even issued writs of possession to the people, one Kabiru Alhaji Tanko and Mustafa Abdullahi, that after he sold the land, the matter was abandoned and never set again on the cost list of the court up to the time of filing this petition. 2. In the second case, our clients instituted a case before the judge for the sharing of the estate of their late father, Magaji Bello, who died as a traditionalist. Even though the judge knew he had no jurisdiction to try the matter, as he rightly explained to our clients, he lured our clients to pay the sum of 300,000 naira to him so that he could attend to his case on time, and our client paid him. When the other party employed the services of a lawyer, the judge transferred the case, but refused to return the 300,000 naira he collected as bribe from our client, despite requests to do so by our client. More so, the judge is in the habit of taking proceedings in his residence as against the court to enable him extort money from unsuspecting illiterate litigants without due regard to the dictates of the law. Prayer. We pray his lordship to set up a strong tribunal to investigate the activities of the judge of Upper Sharia Court, Rijal. While we thank his lordship in anticipation of his prompt action, please accept our warmest regards. Yours faithfully, J.S. Rikoto, Esquire. The content of the petition I just read revealed that it was written by J.S. Rikoto, Esquire, who said he had the instructions of all his clients to petition the applicant. Who are these clients who instructed J.S. Rikoto, Esquire to write the petition? In the body of the petition, J.S. Rikoto, Esquire did not mention the names of his clients. However, he identified himself in the petition to be a counsel involved in the two cases. That's the one between Ibrahim Abubakar and 3 others, and Tanko Abubakar and 2 others, and the other suit between Auta Magaji Bello versus Zagi Timbi and 6 others, presided over by the applicant at Upper Sharia Court Region. The content of the petition discloses that J.S. Rikoto, Esquire, represented the defendants in the suit FI 2018, and the plaintiff's suit in F1051 2023. It is therefore clear to me that the clients who instructed J.S. Rikoto, Esquire, to write the petition are the defendants in the first suit and the plaintiffs in the second suit. That is to say, the complainants in the petition are the defendants in suit CV F1 2018, who are Tanko Abubakar and 2 others, and the plaintiff in suit F1051 2023, who is Auta Magaji Bello. Although the body of the petition did not specifically mention the names of the persons who instructed the writing of the petition, a holistic reading of the content of the petition revealed the persons on whose instruction the petition was written. Having carefully examined the content of the petition, it is observed that the complainants in the petition were clearly identified and known to the applicant who presided over the 2 cases. In my view, the petition satisfied the provisions of Regulation 54.2 of the First Respondent Regulations 2018. It is also the case of the applicant that there was no complaint against him, upon which the first respondent proceeded to conduct a disciplinary proceeding against him. According to the applicant, the petition was withdrawn through a letter dated 8 March 2024 and received by the first respondent on 11 March 2024. The petition having been withdrawn, there was no longer any complaint against him, and there was nothing left for the first respondent to act upon. Therefore, all actions and decisions taken or conducted in relation to the withdrawn petition are illegal, null, and void. The letter of withdrawal of the petition is Exhibit Bobi 5, written by J.S. Rikoto, Esquire. The letter is dated 8 March 2024 and contains that he has the instruction of our clients, quote and unquote, to withdraw the petition as the petitioners and the respondent having engaged in meaningful discussions with a view to settle the matter amicably. The letter was received by the first respondent on 11th March 2024. Before the respondent received this letter of withdrawal of the petition had been forwarded to the applicant for his response, and the applicant had submitted his response to the petition. The applicant's response to the petition is Exhibit C of the respondent's counter affidavit dated 29 February 2024. Upon receipt of the applicant's response, the first respondent set up a committee to investigate the allegations in the petition on 6 March 2024. This was before it received the notice of withdrawal on 11th March 2024. The committee, having been constituted, started its proceedings on 14th March 2024. Now, the contention of the applicant is that when the first respondent received the letter of withdrawal of the petition, it ought not to proceed to conduct hearing into the allegations of the petition. From the facts of this application, the first respondent had already commenced action towards the investigation of the allegations in the petition before the letter of withdrawal of the petition was received. In that circumstance, was the first respondent right to proceed with investigation into the petition? I have not seen any provision in the first respondent regulation which required the first respondent not to proceed with investigation into a complaint against a staff once notice of withdrawal of the complaint is received. Rather, I find this provision in Regulation 56 of the first respondent regulation, which says as follows, quote, in any case which comes to the attention of the commission, if the commission is of the opinion that disciplinary proceedings be instituted against an officer for any misconduct, the commission may, notwithstanding any provisions of these regulations, initiate such proceedings in that manner as it thinks fit. What this provision means is that where any case of misconduct against an officer comes to the attention of the first respondent, and the first respondent is of the opinion that the case warrants investigation, the provision vests the first respondent with the discretion to initiate disciplinary proceedings against the officer. In this case, allegations of misconduct against the applicant was brought to the attention of the first respondent by the petition in Exhibit Bobby 3. Once the first respondent sees reason to institute disciplinary proceedings against the officer, a withdrawal of the complaint or allegation by the complainant cannot stop the first respondent from initiating or continuing with the disciplinary proceedings. Learned counsel for the applicant relied on the case of Folari versus Ayanriola Supra to support his argument that the withdrawal of the petition terminated the complaint against him. The case cited by counsel has to do with notice of withdrawal of an appeal in the Court of Appeal by a party who initiated the appeal. Such a withdrawal of an appeal is regulated by rules of the Court of Appeal. Besides, parties to a suit are at liberty to discontinue their suits or settle the disputes between them at any time. It is a different thing in relation to a petition of misconduct written against an employee to his employer. A complaint about the acts of an employee constituting misconduct in the employee to his employer is not a case between the complainant and the employee. Rather, it is a disciplinary case between the employer and the employee, as the complaint relates to infractions of the conditions of service regulating the employment. Thus, unlike a matter in court between parties, a complaint to an employer against an employee for breach of the codes of the employment is not a matter a notice of withdrawal will simply terminate. Once the employer has been notified that his employee has committed acts amounting to misconduct under the terms and conditions of the employment, the employer has the right to investigate it or to decide on the appropriate course of action against the employee. Consequently, the fact that petitioners later sent a letter of withdrawal of their petition does not preclude the first respondent from conducting investigation into the petition if it appears to the first respondent that the petition reveals some acts of misconduct committed by the applicant. It is for this reason the authority relied on by learned counsel for the applicant will not apply to the peculiar nature of this case. It was shown in the respondent's counter affidavit that the petitioner who wrote a letter of withdrawal of the petition later had a change of mind and appeared before the committee to adopt the petition. It was also averred that J.S. Rikoto Esquire testified as PW1, while two other witnesses, Saidu Hassan and Dabe Diga, testified for the petitioners before the committee. I have seen the report of the committee. It is Exhibit Bobby 6. J.S. Rikoto Esquire, Saidu Hassan, and Dabediga appeared before the committee and testified for the petitioners. I did not find anywhere in the record of the committee where the petitioners or any of their witnesses said they were not interested in pursuing the petition against the applicant, or that they appeared before the committee under duress. In my view, the appearance of witnesses before the committee to prove the complaint against the applicant has invalidated the earlier letter of withdrawal of the petition. It is also my view that the withdrawal of the petition did not terminate the complaint against the applicant, nor did it bar the first respondent from instituting disciplinary proceedings against the applicant in respect of allegation of misconduct, which came to the attention of the first respondent via the petition. And therefore, I cannot fault the first respondent when it proceeded to investigate the petition despite the notice of withdrawal of the petition. The applicant's complaints in this application include irregularities in the proceedings of the investigation committee set up by the first respondent to investigate the petition against the applicant. From the averments in the affidavit of the applicant and the submissions of his counsel in the written address, I have ascertained the following complaints made by the applicant with respect to the proceedings of the committee. 1, that new allegations were made against him by the committee, which allegations were not contained in the petition served on him. 2, that the first respondent acted as a judge in his own case by being the accuser, the investigator, and a judge at the same time. 3, that the allegations of misconduct for which the applicant was sanctioned relate to perceived procedural irregularities or error in the cases before him. I will examine each of these complaints. The applicant said that all the material allegations relating to bribery and corruption leveled against him in the petition were not proved. At that point, the petition ought to have been dismissed by the committee, but the committee proceeded outside the terms of reference to frame new allegations of misconduct against him, which allegations were not part of the petition originally served on him. The fresh allegations were also the basis of the committee's findings against him. As a result, he was not afforded adequate opportunity to prepare his defense to the new allegations. Counsel for the applicant argued that the action of the committee contravenes Regulation 59(1) and 3(7) of the first respondent's regulations and breached the applicant's right to fair hearing. He said Regulation 59(1) and 3(7) provides as follows. 1, where it is presented to the commission that an officer has been guilty of misconduct and the commission does not consider the alleged misconduct serious enough to warrant proceedings under Regulation 59(3) with a view to dismissal, it may cause an investigation to be made into the matter in such manner as it considers proper, and the officer shall be entitled to know the whole case against him and shall have adequate opportunity of making his defense. 3(7). If during the course of the inquiry, further grounds for dismissal are disclosed and the Judicial Service Commission deems it fit to proceed against the officer upon such grounds, the officer shall, by the direction of the commission, be furnished with a written statement about them in addition to the original grounds. I have carefully examined the content of the petition and the report of the committee to determine this aspect of the applicant's complaint. I have also seen Exhibit Bobby 4, being the letter from the first respondent constituting the investigation committee. One of the complaints given to the committee to investigate is the petition against the presiding judge, Upper Sharia Court Rijal, Honorable B.A. Bobby, for gross misconduct and corrupt practices. The terms of reference of the committee are to investigate the allegations raised in the complaints and give recommendations to the commission. Now, what are the allegations raised in the petition against the applicant, which the committee was to investigate? I have earlier set out the content of the petition against the applicant in this judgment. The petition alleges gross misconduct and corrupt practices, and these allegations relate to the applicant's conduct in the 2 cases before him at the time as the Sharia Court Judge, Upper Sharia Court Rijal, Niger State. The 2 cases are suit number USC RJCV F171 2023 between Atahiru Abubakar and others versus Ibrahim Abubakar and 4 others, and F1057-2023 between Autamagaji Bello and others versus Zagi Timbi and others. The subject matter of both matters is the sharing of estate. The petitioner's complaint against the applicant in the first case are that the applicant's attention was drawn to the fact that there's a pending case to the same effect, but he neglected the case and ordered the petitioners who had been in possession of their farms for over 50 years to stop work on the farm until it is distributed. The petitioners informed the applicant that their farms are not part of the estate of the deceased, but he arrested 8 of them, detained them, and collected the sum of 113,000 naira for bail. The applicant colluded with the plaintiffs and sold one of the lands for 3 million naira. The money was shared between the applicants and the plaintiffs without the knowledge and notice of the remaining heirs. 3, the applicant sold the land to the petitioner's tenants and informed the tenants that he has confiscated the land and it is now the property of the court. When confronted, the applicant denied selling the land. 4, the applicant also issued writs of possession to the people, and the land was sold to one Kabiru Alhaji Tanko and Mustafa Abdullahi. 5, after the applicant sold the land, the matter never came up again on the cost list of the court. The petitioner's complaints in the second case are as follows. 1, the applicant lured the petitioner to pay the sum of 300,000 naira to him so that he could attend to his case on time, and the sum was paid to him. 2, the applicant later transferred the case but refused to return the sum of 300,000 naira which he collected as bribe from the applicant. Three, the applicant is in the from the petition. I'm sorry, I misted the petition. 3, the applicant is in the habit of taking proceedings in his residence as against the court to enable him extort money from unsuspecting illiterate litigants. In view of the terms of reference, the committee is to investigate the above allegations against the applicant arising from his conduct in the two cases. The report of the committee, which is Exhibit Bobby 6, reveals that the committee gave opportunity to the petitioners in both cases to call evidence. The applicant was present when the petitioner's witnesses gave evidence, and he cross-examined the witnesses. The applicant gave his own evidence and called witnesses. Documents were received in evidence from the parties, including the record of proceedings of the two cases, and the committee put questions to the witnesses. After hearing the evidence of the petitioners and the applicant in respect of each case, which were the subject matter of the petition, the committee proceeded to make its observations, findings, and recommendations as pages 54 to 59 of the report. With respect to suit number F171-2023 between Atahiru Abubakar and others versus Ibrahim Abubakar and 4 others, the committee made these observations. 1, the above suit was initiated by one Atahiru Abubakar for sharing of the estate of late Alhaji Abubakar Serkin Noma through the petitioner client, Saidu Saliu, PW1, was not, though the petitioner client, Saidu Saliu, PW1, was not listed as either a plaintiff or a defendant in the suit, notwithstanding his intention to be joined as a party in the suit as page 452 of the record of proceeding of the court. The above suit was filed on 14 June 2023 and slated for mention on 15/6/2023, but the matter was not mentioned due to the absence of some of the defendants, and those present declared before the court of their intention to employ the service of counsel as captured at page 452 of the record of proceedings. 3, 4 out of 5 of the alleged estate of the deceased presented before the court for distribution to the heirs were expressly declared to be in dispute by the plaintiff as captured at page 451 of the record of proceedings of Upper Sharia Court Rijal. 4, the respondent Bashar Awal Bobi ordered the plaintiff and his counsel to sell off one of the disputed land situated behind Central Primary School, Rijau, on the oral application of the plaintiff's counsel made on 22/6/2023, as seen at page 455 of the record of proceedings of the court. 5. Following paragraph 4 above, the plaintiff sold off the disputed land described in the preceding paragraph for a consideration of 3 million naira. See pages 456, 466, and 473 of the record of proceedings. Also, PW1 and the respondent gave evidence to the fact before the committee that the land in dispute was sold. 6. The 3 million naira being the proceeds of the sale of the disputed land, the respondent ordered the plaintiff to keep the money under his custody on the basis that the court has no safe. See page 473 of the record of proceedings. 7. In another breath, the same respondent gave an order that the plaintiff should use the money to maintain themselves. See page 456 of record of proceedings. After the sale of one of the disputed land, there was no further proceeding in regard to the items listed to be shared to the heirs, as seen at page 1 of record of proceedings. 9. We observe that the 113,000 naira the petitioner alleged was given to the respondent in respect of the first information report filed before the court. Such allegations could not be substantiated. On the basis of these allegations, the committee made the following findings. 1. The suit between Atahiru Abubakar and others versus Ibrahim Abubakar and 4 others filed before Upper Sharia Court, Rijau, on 14/6/2023 is civil in nature because it revolves around the issue of distribution of deceased estate. 2. The judge never mentioned the matter to the hearing of the defendant before conceding to the oral application of the plaintiff's counsel for the disposal of one of the estates in dispute presented to the court by the plaintiff for distribution. 3. The defendants were never put on notice to join issues with the plaintiff in relation to the oral application for the disposal of the disputed land situated behind Central Primary School, Rijau, in line with Order 6 Rule 3 of Niger State Sharia Civil Procedure Rules 2009. 4. The judge did not resolve the dispute surrounding the land before he ordered for the sale of the land. 5. Following the directives of the respondent on 12/7/2023 at page 473 of the record of proceeding, that the plaintiff should keep the proceeds of the sale of the land for safekeeping, the committee directed the judge to recover the said proceeds and deposit same in the account of Judicial Service Commission. Such directive of the committee was not complied with. 6. The order of the judge that the plaintiff should keep 3 million naira contravenes the provision of Order 14 Rule 2 of Niger State Sharia Civil Procedure Rules 2009. 7. The judge went further to issue writs of possession to the buyers of disputed land, Kabiru Alhaji Tanko and Mohammed Mustafa Abdullahi. The writ of possession issued was marked as Exhibit D and E. It is our finding, 8, it is our finding that such proceeds of sale of land was not distributed to the heirs in line with Islamic injunction. 9. The alleged sharing of 3 million naira between the respondent and the plaintiff by the petitioner has not been proved, as no evidence, orally or documentary, was presented by the petitioner before the committee establishing such allegation. 10. On the issue of 113,000 naira allegedly collected by the respondent from the petitioner's witness, PW1, it was not established against the respondent. 11. It is our finding that paragraph 2 to 9 above amount to serious misconduct in view of the provision of Regulation 58(1)(9) of the Judicial Service Commission Rules of 2018. Now, with respect to suit F1057/2023, Altama Gaji Bello and others versus Zagi Timbi and others, the committee made the following observations. 1. Altama Gaji and Dabe Diga initiated suit number F1057/2023 against Zagi Timbi and others before Upper Sharia Court Region, presided over by the judge for distribution of estate left behind by their late brother. 2. The distribution of the estate could not be effected by the court following an objection from one barrister, Amorupa, that is second defendant counsel, challenging the jurisdiction of the court on the ground that his client, that is Serkin Baka, is not of Muslim faith and never consented in writing to be tried by Upper Sharia Court. 3. Following the preceding paragraph, respondent declined jurisdiction and consequently struck out the suit. Sequel to the striking out of the suit by Upper Sharia Court, and the parties filed their matter before District Court Region for proper determination. 4. Dabe Diga, one of the plaintiff, alleged that the respondent demanded and collected the sum of 380,000 naira to facilitate the distribution of the estates. Based on the observation of the committee made these findings. Based on the above observations, the committee made these findings. 1. It is our finding that the judge assumed jurisdiction in this matter without first obtaining a written consent from the parties in line with Section 17(2) of Sharia Administration of Justice Law 2021 as amended. 2. The later act of the respondent, Upper Sharia Court Judge, striking out suit number F1 OS1 2023 upon oral application of counsel does not offend any law or rule of court. In fact, it is in tandem with the law or rules applicable to Sharia courts, particularly Section 15 and 17(2) of Sharia Administration of Justice Law 2021 as amended. 3. The sum of money, that is 380,000 naira, allegedly demanded and given to the respondent by Dabe Diga, could not be proved. This is because Elegasa Magaji, DW1, with whom Dabe Diga allegedly took the said sum to the respondent, testified before the committee as DW1 and categorically refuted such an allegation, and no documentary evidence was tendered before the committee that may contradict the testimony of DW1. Thus, the claim of the petitioner via PW1 of the respondent collecting the sum of 380,000 naira was not substantiated. Now, the committee, in conclusion, made the following recommendations. Based on the above, particularly paragraph 11 of our findings in suit number F17123, the respondent has failed to comply with the provision of Regulation 16(1) of the JSC Rules 2018. The committee therefore concludes that the respondent's conduct amounts to gross misconduct as defined under Regulation 51 of the JSC Rules 2018. The misconduct includes the following. 1. A. Failure to mention the matter to the parties. B. Failure to resolve the disputes in the land matter before ordering it to be sold. C. Failure to give the defendants opportunity to respond to the oral application and the plaintiff's counsel which eventually oral application of the plaintiff's counsel, which eventually led to the sale of land. D. Wrong issuance of the writ of possession. E. Failure to deposit the proceeds of sale of the land 3 million naira in an appropriate account. Sequel to the above, the committee recommends the following. The warrant which entitles the respondent to sit as a judge be withdrawn. 2. He should be converted to an administrative staff and be returned to the headquarters. Now, upon a careful examination of the findings of the committee in the two cases and the recommendations of the committee, it is observed that the committee cleared the applicant of the allegations in the second case. This is even more so as the recommendations of the committee relate to its findings on the first case. The committee clearly stated in its recommendation that the misconducts found against the applicant arose from paragraph 11 of its findings in suit number F17123. Accordingly, the punishments recommended to the first respondent by the committee were in respect of its findings against the applicant in the first case, being suit number F17123. Any new allegation arising from the second case can only have effect on the decision against the applicant if it was considered in taking the decision against the applicant. In this case, the report of the committee reveals that no decision against the applicant was reached in respect of the second case. Since the applicant was not indicted for any misconduct in respect of the second case, merely making a finding without making a recommendation or taking a decision on the finding does not give the applicant any cause to complain. In the committee's findings on the first case, it found that the petitioner's allegation of sharing 3 million naira between the applicant and the plaintiff in the case, and the allegation that the applicant collected 113,000 from the petitioner's witness were not proved. The committee, however, found that in the case, the applicant, without resolving the dispute in the suit, ordered one of the lands to be sold. The applicant made the order for the selling of the land without hearing for the defendants in the case, and instead of directing the proceeds of sale of the land to be deposited into an appropriate account, he entrusted the money, 3 million naira, to the plaintiff. The committee also found that the applicant wrongly issued writs of possession on the land to the buyers. After the sale of one of the lands, there was no further proceedings in the matter. Although the committee found that the allegations of collecting money for bail and sharing of proceeds of sale were not proved, those were not the only allegations made against the applicants in the first case. In the petition, the petitioner's complaints on the first case surrounded issues of selling of land without their knowledge while the case was still pending in court, disposal of the proceeds of sale in the sum of 3 million naira without the knowledge and notice of the remaining heirs, issuers of writ of possession to the buyers, and the case being abandoned in court since the time of the sale of the land. The misconducts B, C, D, and E, for which the committee indicted the applicant at page 59 of the report, are not new to the petition. They relate to and flow from the complaints in the petition. Therefore, contrary to the belief of the applicant, the committee did not frame new allegations against him. The applicant was aware of these allegations about his conduct in suit F17123 since the petition was served on him. He also heard the evidence of witnesses who testified before the committee. He also called evidence in defense of himself. He cannot therefore claim to have been denied fair hearing with respect to the misconducts found against him by the committee. In the result, I do not see how or which area the committee contravened Regulation 59(1) and 336 of the First Respondent Regulations or the Rules of Natural Justice. The applicant further alleged that the committee set up by the first respondent was the one who directed the applicant to recover the sum of 3 million naira from parties to a case and deposit the money into the account of the first respondent. Accused the applicant of misconduct for failing to deposit the money as directed by the committee and sanctioned him for failing to comply with the directives. According to the applicant, the committee was the accuser, investigator, and the judge at the same time, and this contravened the applicant's right to fair hearing and the rules of natural justice. One of the allegations against the applicant with respect to suit number F171/2023 is that he colluded with the plaintiffs to sell off one of the lands in the estate for distribution for 3 million naira and shared the money between him and the plaintiff. At pages 32, 33, 34, and 36 of the report, the applicant, responding to the questions from the committee, stated these facts. 1. The subject matter of suit 71/2023 was sharing of estate, but he did not share the estate. 2. He confirmed that the record of proceeding of the case contains that he directed the portion of the land to be sold by the plaintiff to maintain themselves. 3. His record also contains that the land was sold for 3 million naira, and he ordered that the money be kept in the custody of the plaintiff. Since the court has no safe. 4. He also confirmed that the money is still with the plaintiff. And that he has not shared the money to the heirs because the defendant did not attend court. 5. When asked if he can direct the plaintiff to bring the money, the applicant said if the committee so directs, he will order the plaintiff to bring the money. The applicant told the committee that the court's account was dormant. 6. The committee then directed the applicant to order the plaintiff to bring the money and pay into the first respondent's account given to the applicant. Paragraph 5 of the findings of the committee at page 56 of the report is that, quote, following the directives of the respondent on 12/7/2023 at page 473 of the record of proceedings that the plaintiff should keep the proceeds of the sale of the land for safekeeping. The committee directed the judge to recover the said proceeds and deposit same into the account of JSC. Such directive of the committee was not complied with. Then the misconducts for which the applicant was indicted by the committee and recommended to be punished at page 59 of the report include, quote, E, failure to deposit the proceeds of the sale of land, 3 million naira in an appropriate court. It is in view of these facts that the applicant contended that the committee was not the one who accused him of failing to deposit the money as directed and also sanctioned him for failing to comply with the directives. That is, the committee was the accuser, investigator, and the judge. Now, when the committee said one of the misconducts by the applicant was failure to deposit the 3 million naira proceeds of sale of the land in an appropriate account, the applicant appears to think that the indictment was in respect of his failure to comply with the directives given to him by the committee to recover the money from the plaintiffs and deposit same into the account of the first respondent. The finding of failure to deposit the proceeds of sale of the land, 3 million naira in an appropriate account, is clear. It cannot be interpreted to mean that the committee accused the applicant of failure to comply with the directives of the committee to recover the said proceeds and deposit same into the account of the JSC. The proceedings of the committee in the report revealed that upon sale of the land, which was done when the matter was yet to be concluded, the applicant was informed of the sale and the amount realized, but he directed the plaintiff to retain the money, claiming the court had no safe. It is clear to me that the committee's view was that the applicant ought to have deposited money into an appropriate account in that circumstance. It was his failure to do so since the time of sale of the land that informed the finding of the committee. The recommendation of the committee that the applicant be sanctioned was not failing to comply with the directives of the committee. I do not find merit in the applicant's allegation that the committee accused him of the misconduct of failing to deposit money as directed by the committee and also acted as the investigator and the judge at the same time. The applicant further contended that in the findings of the committee, he was held personally liable and sanctioned for perceived legal errors or procedural mistakes allegedly committed by him in the course of legal proceedings conducted by him. According to counsel for the applicant, parties involved in the case have statutory right of appeal over such perceived procedural irregularities or errors committed by the applicant in the matter. Counsel relied on section 3341 of the Sharia Criminal Procedure Code to argue that the applicant cannot be held liable for such procedural irregularities or error. In response, learned counsel for the respondent submitted that the misconducts the committee found the applicant to have committed in the course of suit F17123 are not legal errors excused by section 334 of Sharia Civil Procedure Code. The conduct of the applicant constitutes gross misconduct under Regulation 58 of the First Defendants Regulation. It was also submitted that the Sharia Criminal Procedure Code is not applicable to the case of the applicant because it governs criminal matters. Meanwhile, the cases before the applicant, which were the subject of the petition, were civil in nature. I have examined the Sharia Criminal Procedure Code of Niger State, and particularly the provisions of section 334 thereof, 3341 thereof. The provisions of section 331 cover the Sharia court judge in his criminal jurisdiction or while presiding over criminal cases. I did not see any provision that extended that protection to civil cases. I must also make the point that Regulation 16.1 of the First Respondents Regulation expects a judicial staff to study and comply with laws, rules of court, and schedule of duties, and should conduct himself at all times in a manner that promotes public confidence in the integrity, impartiality, and independence of the judiciary. In the recommendation of the committee at page 59 of its report, it found that the applicant violated this provision of the regulation and decided that the conduct of the applicant amounted to a misconduct under Regulation 58(1). In my view, where procedural irregularities or error amount to misconduct under the condition of service, the judicial staff can be disciplined by the employer without prejudice to the right of the parties to the case to appeal. The applicant also complained that Regulation 7427 of the First Respondent Regulation, Exhibit Bobby 9, requires that the first respondent communicates his decision on each allegation made against the applicant to him. But in this case, the decision of the first respondent on 12 September 2024 on the allegations leveled against the applicant were not communicated to him as required by the regulation. In his affidavit, the applicant said after the conclusion of the proceedings of the committee on 19 September 2024, he was served 2 letters of notification dated 13/9/2024, demoting him with 2 ranks from Principal Sharia Judge 2 to Principal Registrar 2, and removing him from his position as a judge. The letters made reference to the first respondent's decision dated 12 September 2024, but the decision was never served on him till date. The 2 letters of notification are Exhibits Bobby 7 and Bobby 8. Learned counsel for the applicant submitted on this issue that the applicant's constitutional right to fair hearing includes his right to know the decision passed by the first respondent on the allegations leveled against him. According to counsel, the failure of the first respondent to communicate or serve its decision of 12 September 2024, which decision was the position of the first respondent on the allegations leveled against the applicant, which led to his removal from the office of a judge on the applicant renders the decision irregular, ultra vires, unlawful, and contrary to Regulation 7427 of the First Respondent Regulation and Rules of Natural Justice. The respondent's response to this allegation is that the decision of the first respondent on the recommendation of the committee was communicated to the applicant via Exhibit F and G, which are the same with Exhibits Bobby 7 and Bobby 8. Regulation 7427 of the First Respondent Regulation provides as follows. Quote, the Commission, after considering the report and any further evidence before it, shall then decide on the guilt or responsibility of the officer on the allegations made against him, and if the officer is not exonerated, shall decide on the punishment to be meted out, and the decision on each allegation made against the accused officer shall be communicated to him. Unquote. By this provision, after the investigation committee had submitted its report to the first respondent is required to consider the report, and upon deciding that the officer is guilty of the allegation, it shall also decide on the punishment to be given to the officer. The area of contention in this application is where the regulation provides that the decision on each allegation made against the accused officer shall be communicated to him. This part of the provision is clear and unambiguous. It is not difficult to understand that the decision of the first respondent is required to communicate to the officer is the decision taken as to the punishment to impose on the officer. I have seen Exhibit Bobby 7 and Bobby 8, both dated 13 September 2024. They are from the first respondent to the applicant. The applicant was notified in both letters that he has been removed as Sharia judge with effect from 12/9/2024 and demoted with 2 ranks from Principal Sharia Judge 2 to Principal Registrar 2 with effect from 12/9/2024. In paragraph 11 of the documents, the first respondent remarked thus, quote, JSC decision of 12/9/2024 refers. This is the statement the applicant relied on to contend that there was a decision of the first respondent on 12/9/2024, which was not served on him. It is clear from Exhibits Bobby 7 and Bobby 8 that the punishments communicated to the applicant in the exhibits were the decisions taken by the first respondent on 12/9/2024. The applicant confirmed in paragraph 28 of his affidavit that he was served Exhibits Bobby 7 and 8. Accordingly, I do not see merit in the contention of the applicant that the decision of the first respondent on 12/9/2024 was not communicated to him. In view of Exhibits Bobby 7 and Bobby 8 served on the applicant, I find that the first respondent complied with Regulation 7427 of the First Respondent's Regulation. The applicant also made allegations of defamation against the respondents. He said the petition Exhibit Bobby 3 contains accusations of criminal misconduct of receiving bribe in the sum of 380,000 and the corrupt practice of sharing 3 million naira between himself and a party to a case before him. When the petition against him was withdrawn, the first respondent, however, insisted on proceeding against the applicant but failed to have the allegations established against the applicant. Since the applicant was wrongfully accused of criminal misconduct which were not proved against him, he is entitled to award of damages for the damages to his character against his employer as a remedy for the unproven allegation of criminal misconduct. The applicant gave particulars of the wrongs and damages he suffered in paragraph 15 of his affidavit in support of the motion. Relief 7 and 10 sought by the applicants are claims in defamation. This aspect of the applicant's application is not a matter within the purview of judicial review. It's a claim founded in the tort of defamation, which cannot be instituted by a motion or proved by affidavit evidence. An action in defamation is a separate subject from judicial review. Thus, a claim in defamation cannot be joined to an application for judicial review. Similarly, it has been pronounced judicially that the subject matters which this court can entertain, as spelled out in Section 254C of the Constitution of the Federal Republic of Nigeria, 1999, do not include actions in defamation, which is an action in the realm of torts. See Akpan versus University of Calabar, 2016. See also EcoBank Nigeria Limited versus Idris, 2021. Accordingly, cases or matters founded in the tort of defamation cannot be entertained by this court, even if the tortious action happened in the course of the employment. Let me add that the accusations of criminal misconduct of receiving bribe in the sum of 380,000 and the corrupt practice of sharing 3 million naira between himself and a party to a case before him were made against the applicant by the petitioners who submitted the petition to the first respondent. These persons have not been joined in this suit as defendants in respect of this aspect of the case of the applicant for defamation. The applicant cannot claim in defamation against the first respondent without joining the persons who sent the petition to the first respondent. The fact that the petitioners are not parties in this suit renders all the claims of the applicant founded on the defamation incompetent. The result of the foregoing is that the aspect of this application relating to the tort of defamation is not competent before this court. In an application for the order of certiorari to bring the proceedings of an administrative body before the court to be quashed, it is the duty of the applicant to provide cogent evidence to establish the grounds of the application. Where this is not done, the court will have no business interfering with the proceedings or decision of the administrative body. Having examined the grounds raised in this application for seeking to quash the proceedings of the first respondent's investigation committee and the decisions of the first respondent in the disciplinary action against the applicant, I do not find merit in any of the grounds of his complaint. Therefore, this application fails. While reliefs 7 and 10 are struck out, reliefs 1, 2, 3, 4, 5, 6, 8, 9, 11, and 12 are dismissed. Parties shall bear their respective costs. This is the decision of the court and it is entered accordingly.
Go, please. My Lord, we are very grateful for this wonderful reading. Thank you, my Lord.
It's quite a long one, isn't it?
Yes, it is, my Lord.
It's quite a long one. So I'll make necessary corrections and make your judgment available to you as soon as possible, if possible today. The worst scenario could be tomorrow.
Thank you.
As God pleases.
Thank
Thank you, my Lord.
Thank you very
I'm
much.
most grateful.
Thank you. So at this point, I think I should take a 10-minute break. I will remain online. It may not be up to 10 minutes so that I can catch my breath before I go on to the next matter.
Okay, my lord. Okay, my lord.
Thank you.
Thank
Yes,
you, my
ma'am.
Lord.
Okay, I think you should get ready to resume sitting now. When you are ready, Mohammed, you can call the next case. Let's do it
Okay, my lord.
quickly. Yes.
NICN/ABJ/408/2022 between Mr. Ochigbo Shaibu Sunday and People's Plus Management Service Limited. Parties absent.
Appearances.
May it please the court?
Yes.
I am US initials.
Yes.
Star 1. My lord, Star 1 is spelled as SAA
Yes.
WUAN.
Yes. Yes. N.
Yes, my lord. N as in Nigeria.
Yes.
According the brief of Valentine Obiajulu. Obiajulu, my lord, is spelled as OBIAJULU.
Yes.
My appearance is for the claimant. I sincere apologies for the absence of the claimant, my lord.
Thank you. Yes.
With greatest respect to the Honorable Court,
Yes.
my name is Solomon Onamka. My lord, Onamka is
Yes.
spelled UNAMKA.
Yes.
My humble appearance is for the defendant.
Again, I'm going to proceed to deliver this judgment, and I'll be reading from my system.
As the court pleases.
As court pleases.
By a complaint filed by the claimant on 22nd December 2022, he sought the following claims against the defendant. I have listed out the claims. There are altogether 7 of them. I have also summarized the case of the claimant and the defendant, as well as it touched on the final written addresses. I'll go straight to my decision. I have considered the evidence adduced by the parties and the written submissions of counsel for the parties. I have also examined the documents tendered in evidence. The sole issue I will determine in this judgment is whether the claimant has proved the claims sought and entitled to the grant of the claims. The claimant was employed by the defendant on 15th November 2007 as security officer, and on 31st July 2015, his employment was terminated. The employment letter is Exhibit C1, while the letter through which the termination of his employment was communicated to him is Exhibit C9. In the letter of termination of his employment, the claimant was informed that, quote, your services are no longer required by People Plus Management Services Limited with effect from August 3, 2015, unquote. The first claim sought by the claimant in this suit is for the court to declare the termination of his appointment as unlawful, illegal, null, and void. It is settled law that an employee who is asking the court to declare the termination of his employment as wrongful or unlawful or null and void, that employee, to be entitled to that relief, must plead and prove the following vital facts: the terms and conditions of his appointment, the circumstances under which his appointment can be terminated under the condition of service, the procedures stipulated in the condition of service for termination of the employment, and the manner in which the termination of his employment breached the said terms and conditions of his appointment. See WAEC versus Oshonebo 2007, AGI versus Chad Basin Development Authority 2016, where it was held that whether one is suing for wrongful dismissal from an employment with statutory flavor or under common law principle of master and servant, the fact of the employment and the terms and conditions of same must not only be pleaded, but must be proved by evidence before a determination of the wrongful nature of his termination or dismissal can be considered by the court. The implication is that the court can only determine the wrongful or unlawful nature of the termination of an employment based on the terms and conditions of the employment. In other words, an employee challenging the termination of his employment must found his case on the condition of service applicable to his employment. Accordingly, the duty placed on the claimant who is seeking that this court declares the termination of his employment as unlawful, null and void, is to plead and prove the terms of his employment with the defendant and show how the said terms were breached by the defendants in the termination of his employment. I have examined the pleadings and evidence adduced by the claimant thoroughly. What is said is that following the alleged burglary and theft of the belongings of the internal auditor of Zenith Bank in the bank's guest house, where the claimant was posted as security guard on 21st July 2015, he was issued a query on 24th July 2015 by a staff of Zenith Bank Limited, but the defendant did not issue him any query and did not question him over the alleged burglary incidents. On 31st July 2015, the defendant gave him a letter of termination of his employment. This is all the claimant said. In both his statement of facts and in his evidence with respect to the termination of his employment, the claimant failed to mention the condition of service which regulated his employment with the defendant. He also failed to plead the terms and conditions of his employment. The result of these failures is that the claimant did not show the circumstances under which his appointment can be terminated, the procedure to be followed before his employment can be terminated, or how the termination of his employment breached the terms and conditions of his employment. Now, the only complaint which I find the claimant made in this case is that the defendant did not issue him any query and did not question him over the alleged burglary incidents before proceeding to issue him a termination letter. By this complaint, the claimant appears to contend that his employment was terminated as a disciplinary action arising from the burglary incidents. That is also why the claimant expected the defendant to issue him a query and to question him on the incidents before terminating his employment. First of all, the claimant did not plead or mention in his evidence that it is a requirement under the terms and conditions of his employment for the issuance of query by the defendant or be questioned by the defendant before his employment can be terminated. In the absence of such proof, the claimant cannot claim to be entitled to such rights in the employment. Furthermore, I have examined the termination letter to see the reason for the termination of the claimant's employment. The reason is simply that the claimant's services were no longer required. There's nothing in the letter to link the termination to the burglary incidents. Also, the termination is not indicated to be on the disciplinary grounds. The defendant appears to have only exercised a master's inherent right in the employment to terminate the employment. Accordingly, since the employment was not terminated on disciplinary grounds, and having not been shown that the condition of service required service of query and a hearing, the claimant was not entitled to be given a query or be questioned by the defendant before the defendant can terminate his employment. Upon a careful consideration of the facts pleaded by the claimant and evidence adduced by him, I find that he failed to make out a case to justify the grant of the declaration he sought in Relief 1. This conclusion affects Relief 2, where the claimant sought a declaration that he is entitled to be paid salaries and allowances from the date of termination of his employment to the date of judgment in this suit. Having found in this case that the claimant did not present any case to warrant upsetting the termination of his employment remains terminated from the effective date indicated in the letter of termination of his employment. It is trite that a servant whose employment has been terminated cannot claim for salary or allowances for a period he was no longer in the employment. See Springbank versus Babatunde 2012. Consequently, the claimant is not entitled to be paid salaries and allowances since the time his employment was terminated. I hold, therefore, that the claimant has also failed to prove his claim in Relief 2. The claimant sought Relief 3 as an alternative claim to Relief 2. The alternative claim is for the court to declare, in the event that the termination of his employment is valid, that he is entitled to his entitlements upon termination of his employment. There is also Relief 4, where the claimant sought an order directing the defendant to pay his termination entitlements in the sum of 92,087 naira 34 kobo with interest at the rate of 15% monthly from August 2015, when his appointment was terminated, until judgment, and therefore after at the rate of 20% monthly until the sum is fully liquidated. The law is trite that it is where the main claim fails that the alternative claims can be considered. See NEPA versus Ango 2001. See also Corn Oil versus Solomon 2017. Since the claimant's claims in Reliefs 1 and 2 have failed, the alternative claim in Relief 3 deserves to be considered to determine whether he is entitled to be paid terminal benefits. In his evidence, the claimant said in a letter dated 3rd December 2015, the defendant advised him of his end of service account and requested him to report to the defendant to collect his check of 92,087 naira 34 kobo. He visited the office of the defendant and he was given a check in the sum of 92,000 naira. When he attempted to cash the check in Zenith Bank, he met the auditor, who had claimed that his room was burgled on 21st July 2015. The said auditor forcefully collected the check from him, and when he went back to the admin office of the defendant to complain, the office admin told him that his termination is a dismissal and he was not entitled to terminal benefits. The said letter of 3rd December 2015 is Exhibit C10. In defense of his claim, DW1 said, after the termination of the claimant's appointment, the claimant's end of service account was computed and communicated to him via the defendant's letter dated 3rd December 2015, together with a Zenith Bank PLC bank draft number 000-43386, dated 29th October 2015, in the sum of 92,087 naira 34 kobo. A copy of the bank draft, together with a copy of the letter of 3rd December 2015, is Exhibit D1. From the evidence of the claimant and DW1, as well as Exhibit C10 and DW1 and C10 and D1, it is not in dispute that the claimant's terminal benefit was the sum of 92,087 naira 34 kobo. It is also not in dispute that the defendant gave a bank draft to the claimant as payment of his terminal benefit, and the claimant received the bank draft. What the claimant is now saying is that he has not been paid because the bank draft was collected from him by the auditor of Zenith Bank. The case of the claimant in his claim for payment of the same terminal benefits he has collected bank draft for since December 2015 is weak for these reasons. 1. The claimant confirmed that the defendant gave him a bank draft for payment of his terminal benefits since December 2015. 2. He also confirmed that it was not the defendant or any staff of the defendant who seized the bank draft from him. 3. The claimant failed to join in this suit the said auditor of Zenith Bank, who he claimed steals the bank draft, to be heard in respect of the allegations of the claimant against him. 4. Besides, the incidence of seizure of the bank draft from the claimant happened on the same day the bank draft was given to him in December 2015. But he did not tell this court what efforts he made all these years to recover the bank draft from the said auditor of Zenith Bank. The claimant simply went to sleep all these years, only to remember in 2022 that he is yet to receive the value of the bank draft. The claimant's story about the seizure of the bank draft is not convincing. I find it hard to believe that he has not been paid his terminal benefits. By giving the claimant the bank draft for his terminal benefits, the defendant has discharged his obligation to the claimant. It was the claimant who allowed a third party, who is not his employer, to seize the bank draft from him. The claimant cannot therefore claim that the defendant has not paid him his terminal benefits. The result of the foregoing is that I do not find merit in Relief 3 and 4. In his evidence, the claimant said, after the termination of his employment, the defendant sent a letter of termination of his appointment to the resident pastor of his church in his village, being Adupi Ogugu, Kogi State. As a result, his ordination as an associate pastor of his church, which was supposed to take place in April 2017, was called off. He got another employment in August 2019 with Kebi Construction and Engineering Company Limited, but that employment was terminated within 6 months of his resumption because the defendant gave the company a bad report of him. On the basis of these facts, the claimant claims as follows in Relief 5. a declaration that the defendant's act of sending the claimant's letter of termination to the claimant's resident pastor at the claimant's village and the claimant's allegation of theft and criminality in his corporate reference on the claimant submitted to Kebbi Construction and Engineering Company Limited is unlawful and amounts to a defamation of the claimant's character. This claim is a claim founded on the thought of defamation. The cause of action for this claim is not directly linked to the contract of employment between the parties, and it arose after the claimant ceased to be an employee of the defendant. Such a cause of action or claim cannot be entertained by this court. The subject matters which this court can entertain are as spelled out in Section 254C of the Constitution. These subject matters within the jurisdiction of the court do not include actions in defamation, which is an action in the realm of torts. See Akpan versus University of Calabar 2016. See also EcoBank Nigeria Limited versus Idris 2021, where the Court of Appeal held the view that cases or matters which border on the tort of defamation is not one of the subject matters within the jurisdiction of this court in Section 254C 1, 2, and 3 of the Constitution. The Court of Appeal clarified that even if the tortious action happened in the course of the employment, it cannot be used to expand the jurisdiction of this court beyond its jurisdictional scope in Section 254C 1, 2, and 3 of the Constitution. It is therefore obvious that this court lacks jurisdiction to entertain the claim in Relief 5. This claim is struck out. The claimant sought to be paid the sum of 50 million naira as general damages in Relief 6. This sum claimed by him is stated in the relief to be for the unlawful termination of his employment, unlawful seizure of his terminal benefits, and defamation of his character. In Relief 7, the claimant also claimed cost of action in the sum of 2 million naira. In view of my decisions on Reliefs 1, 2, 3, 4, and 5, there is no reason to grant the claimant's claim for general damages or to grant his claim for cost. The claims in Relief 6 and 7 fail. The suit of the claimants lack merit, and it is dismissed accordingly. No order as to cost, judgment is entered accordingly.
As court pleases.
As God pleases. We appreciate the industry of the court for the reading. Thank you, my
Thank
lord.
you.
You're welcome.
We
Thank
appreciate
you.
my Lord for the well-considered judgment. We are most grateful,
Thank
sir.
you. Thank you. So I'll get your judgments across to you between today and tomorrow. The
As court
registrar
pleases.
should be able to give you signed copies tomorrow.
As
As
God
court
pleases.
pleases. We are most grateful,
Stop
sir.
listening.
Thank you very much. Do
Thank
have
you.
a nice day and a fulfilling 2026.
Wish my
Yes, thank
Lord
you,
the
madam.
same.
Thank you, madam.
Thank you, sir.
Thank you. Thank you.
Yes, madam. Yes, madam.
This October was a registrar and the lawyer making fair the case. So I will leave.
Don't give me.